All right, thank you very much for joining us for the webinar today. I see about 40 people have joined in so far, and I believe that a few more are going to be signing up in the next few seconds. Generally, I've seen when the webinar starts at 9:30, people are pretty good about their timing. Still, I think some struggle with joining with their computer. So we'll give a few more seconds and start in just in maybe 30 seconds. And wanted to share my thoughts with you on estate planning. And it is one of the most important things in person's life, especially after you have family, children, and you have a job, and you have accumulated a few assets. And the reason you are at the webinar today is because you've been thinking about either trust or wills, and perhaps you have questions. What is really the difference between the two? And question also, perhaps you're asking yourself, do I really need a trust? So we'll be answering all those questions. All right, so we'll get started. Now, the topic of today's estate planning webinar is on trust and wills, even though the topic on the screen says top 10 estate planning mistakes. Actually, it'll cover wills, trust, and the mistakes people make with their trust planning or not planning, either way. All right. My name is Paul Kalra, and I've been doing estate planning and financial planning for clients for about 30 years. And I've seen pretty much every situation with my clients, success, not so success, so much of success. In each case, I've learned, which I learned from people's experience, which I pass on to my new clients so that I can help them avoid mistakes in their lives. All right, so let's move to the next screen. All right, so we are Signature America Wealth Management. I founded this company about 18 years ago, and I want to make sure that we hold this company to the highest standards. So I have these following rules set forth in my company's agenda. Whenever we hire people, we train them. These are our values, core values, and we are going to treat our clients with these values. Firstly, we care deeply about our clients' welfare, and we put our clients' interests before ours. Firstly, it's just the ethical thing to do. We've been doing it. I've been doing it actually even before I founded the company. That has been my rule, to put clients' interests before my own. And by the way, I started with John Hancock Financial Services about 35 years ago. And after a successful career with John Hancock, that's when I founded Signature America. And so I've had the highest standards to put clients' interest first anyway, before ours. But now we're also fiduciaries, licensed fiduciaries, so which means we are required to put clients' interest ahead of ours. And unlike most financial advisors, such as from Merrill Lynch, Wells Fargo, or your attorneys who are only available during weekday hours, we are available to you over the weekends. And we pride in our honesty, integrity, and fairness. And also want to assure you that our fees are very, very reasonable. Because you might have seen a few seconds ago, what I said was that we hold our clients to the highest standards and we are available over the weekends. That does not mean that we also charge higher fees. Our fees are very reasonable. And I have one rule, which I tell my clients, which I tell my family, and the rule I have lived with. If anyone offers you free service or charges so low that you wonder how are they even breaking even, how are they making any money, then you know there's some agenda behind it. So in that case, run. And also if somebody overcharges you, then to run. I had a situation where I remember very clearly. This was a very, very high net worth client with about $80 million of assets. And he said, Paul, will you join me with for a meeting with my attorney, an estate planning attorney, where this was the first meeting that he had scheduled with this attorney. And I said, okay, I'll go with you, because the client felt more secure with me being there. And we go to this client's fancy offices. The whole floor was owned by this attorney and his law firm, quite a few other attorneys there. And the estate plan, which we had thought based on my past experience and his past experience, that the estate plan might cost maybe $20,000 or $30,000, at the most $50,000. By the time we were done, this attorney was proposing a package of about $150,000 a year initial fee and about $40,000 a year annual fee. And his logic was, well, for your size of estate, the fee is a very, very, very small fraction, and we're going to help protect all your assets. Well, if that was the only way to really protect clients' assets, yeah, we can understand. But all the estate planning he was proposing should have cost only $20,000 or $30,000. The client looked at me, I looked at the client, and as we walked out, the client said, sorry, Paul, wasted your time. Let's not come back anymore. The point being, the attorney's idea was, look, you're so wealthy, so paying $150,000 a year is chump change for you. That's not the way you want to select your financial advisors. All right, and we also care about building and preserving your estate. We want to make sure that your relationship with us profits you, enhances your well-being financially and mentally, so that we can bring peace and calm in your life, knowing that your finances are well taken care of. We help you with income tax reduction strategies. We also help you with estate tax reduction strategies and investment planning strategies, retirement income planning, and old age planning, so that when you're old and feeble, and we're talking old when you're such as 80, 85 years old, 90 years old, not able to manage your finances. We want to make sure that there's enough money to take care of you, enough money for your family to take care of you, and also the money is not being squandered. So asset preservation is very important to us, whether you're during your years when you're alive, asset preservation from lawsuits, asset preservation is from your old age expenses, and also we want to make sure your estate is passed on to your survivors in an easy manner without complications, and we'll be there to help your spouse and children. And another thing is, all the things we said, they mean well to you, but are we living with old knowledge? Is that how we're going to be helping you? That's not how we do it. We stay abreast of the latest changes in laws and tax income strategies. So we are always ahead in terms of helping the client with the best tools available. So now we're going to talk about estate planning mistakes. And you might have thought, hey, what have all those previous things I mentioned to you about retirement income planning and investment planning, etc., what do they have to do with estate planning? Well, they're all part of your estate. So after you've accumulated all your assets, you've been either earning good income or you have retired. Either way, you want to make sure now that assets are preserved and you do not make any estate planning mistakes. If you make those mistakes, then not only you'll end up losing a significant portion of your assets while you're alive, but they can be also mislaid or misspent when you're old or when you pass the assets on to your children. Portion of that can be paid. If not done proper, if you have not done proper planning, a significant portion sometimes can go to IRS in taxes. So we're going to start from number 10 mistake. That does not mean it's the most important mistake. All these mistakes that we're going to cover, they are at random, meaning they're not in order of priority. So we'll count down from number 10 to number 1. So what's the first mistake that I'm going to cover is that's letting your family go to probate court. That's where the topic of the will comes in. Now, did you know that if you do not have a will or a trust, there already is a will set up for you by the state of California? Every citizen of California has a default will. If you do not have a will, then state will distribute your assets based on certain rules they have in the law. So at a minimum, if a person has a will saying, okay, when I die, all my assets to go to my spouse, or half to my spouse and the other half to my children, regardless whichever way it is, it goes to the court system when you have a will. Court then has to go through quite a few steps before the assets are distributed to your children. We'll cover that in a moment. So probate really is the legal process of distributing your assets. Now remember that, the difference between living trust and probate. That probate is the legal process of passing the assets on to your survivors when you die. So what happens? What has a trust got to do with it? Well, the beautiful part about trust is we actually pass your assets on to a trust before you die. So since the assets have been passed on to the trust before you die, guess what? There's hardly anything to probate unless you did not transfer some of the assets to your trust. So let's go through the problem. Let's backtrack first to tell you what happens when you do go through probate. Number one, it's very expensive. And it takes 9 to 18 months to process. Some probates go on for years and years. And some of the big major celebrities, if you put in on Google search, probates of famous celebrities, you'll find some of the very well-known names, which the probate started many years ago and still going on. That's because the celebrity or famous person perhaps was so busy, he never took time to set up a trust. So now his estate is stuck in a probate, which could be based on the default will that's set up by California or the will that the famous personality might have set up. You may be surprised, actually, if you go to Google search, you may actually find the wills of many of our country's presidents. So here's what happens. Firstly, when you have a will and you do not have a trust, it has to be authenticated by the court. So we're going to start from the top left. If you see the screen, the search glass and the magnifying glass. So we're going to start from there. So the court has to authenticate your will if you have a will. Now, you may have specified a trustee, I'm sorry, not trustee, but executor or a representative to manage your affairs. So, and if you have not appointed one, the court will appoint one. So if you have appointed, the court then wants to look at the person, say, are you really the person who was actually assigned a job and task, and are you up to the snuff? And then that person has to post a bond. If the person who is managing your affairs before they're distributed to your survivors, if they make a serious error which causes harm to your estate, then that person is responsible to make up for the damage caused. So court says, well, Mr. Executor, Mr. Personal Representative, we want you to go get a bond that will actually make the estate whole if you mess things up. And one of the things I want you to remember, that anything that goes to court system, once it goes to court system, it becomes a public record. It's a public record, which means your will now is a public record for anyone to see. And again, going back to what I was saying, that wills, if you did the Google search for wills of famous personalities, for famous people, you will actually see all the details in the will as mentioned, that as written by the person who left the will behind. They might have had good intentions and they took time to write the will. Now actually you can see the entire language of the will on websites, because some websites have taken that information from the court system and posted it on their websites, so you can read up everything. So essentially what I'm saying is that if you do not have a trust and you have a will, your will be a public information. So moving back to posting bonds, then we move to the right, you'll see it says locating the decedent's assets. So what that means is now court says, okay, Mr. Executor, go ahead and give us the itemized list of everything that the person who has died, he has left behind. So the executor will locate all the bank accounts, any other assets, real estate, and maybe even personal assets that are from home, everything is logged in. And then it's presented to the court. And a court, by the way, wants the values on the date of the death. Now, can you imagine let's say the executor is now meeting with, they've got all the values and 6 months have lapsed now. And he goes there and shows the values to the judge. The judge says, no. We want the values as of the date of the death, not 2 months or 3 months or 4 months later. So now the executor has to start the process all over again. He might even have to hire some experts, such as for real estate valuation. And he wants real estate valuation as of date of death. So only an expert can compare the values and certify it with his signatures so that they are legit values. So now we move in the middle column to the top. So at that time, now judge says, contact all the creditors of the person who has died. So now executor has to do that. They have to be paid off. After they've been paying off, we're moving to the right column now. Only then at that time, any inheritance taxes due had to be paid. Only then the survivors will receive whatever is left behind. So you see the complication there now? And that's the process that can take 9 to 18 months. So how do you avoid probate? Well, as I mentioned, you need to have a trust, not just any living trust, but a well-designed trust. If it is not well-designed, your estate will end up in the probate court anyway. And as you'll see that a lot of these internet-based living trusts, those are the type of trusts that actually end up in courts. So if you were to do a Google search on trust court cases, and you'll see tens of thousands of websites will pull up court cases will pull up, which talk about the lawsuits that have happened or are in the process right now, but only because the trust was not designed properly. So during your lifetime, it's business as usual when you have a trust. Many people think once you have a trust, well, maybe you just complicated your life. Not at all. All that has happened is in your trust, all your assets, your bank account, your properties, and whatever else you have, all that has happened is instead of having your name directly on it, it is now the trust name on it. Trust owns it. And who is actually the boss of the trust? You are the boss of the trust. You are the trustee. You decide every event and everything about the assets that you spend, blow money any which way you want, just as if it was in your name. The only thing being, it is in your trust name. So while you're alive, the life goes on just as usual, as if nothing happened. Okay? And you're in total control, and your living trust is totally amendable. Suppose you have some terms you specified in the trust that, upon my death, I want so much to go to my spouse, so much to my children, and perhaps you want money to be distributed over a certain period of time. Well, as time goes by, you can change those terms, you can amend that trust. And there are situations, for example, you may put a certain person as a trustee of the trust. perhaps your brother, because your children are younger. And at that time, so everything worked out fine. You put your brother or somebody else as the successor trustee after you, you being the primary trustee. Time goes on, your children now have grown up, they're mature, so you can actually go back to the trust and with the help of an attorney, change the terms of the trust and take your friend's name off or brother's name off and put your children as perhaps the secondary trustees. So essentially, a trust is merely a standby vehicle. It comes into action upon your death. So now, believing that all living trust plans are the same, not as I mentioned to you that if it is not a well-designed trust, it's back to square one. You may end up in the court anyway. So that's why you want to only work with people who are experienced in trust planning. Now, just like cars, you know that all different brands of cars, they're not all alike. Some are built cheaply, some are built very expensive, some are just they charge high simply because they have high fluting names, but that does not necessarily make them better. But still, higher priced cars generally are built better than lower priced cars. So at the same time, you want to get a car that has a reputable established brand name. So point being, you want to stay with trust planning also with people who have experience and who have been doing it for a long time. Now, how would you know whether trust was done correctly or not? Just like with car, you don't want to find out that car was not built safe after the crash. That's too late. Same thing with the trust. You want to do it now because by the time your children find out the trust was not done correctly or does not have the terms specified properly and it's going to mess up their lives, guess what? It's too late. By that time, you're gone. Now, question, for example, one of the questions is, will your living trust actually avoid conservatorship and probate? And here's what happens. As I alluded to you a few seconds ago, if you have a trust, but you have not passed your trust, your assets are into the trust. If you're not changed the title to the trust, well, then they are going to go through probate just the same. So a good attorney will advise you after you've created a trust to transfer the assets into the trust. And we will actually send you letters to remind you that you need to change the title of the assets. And if need be, we'll issue you more and more letters that you need to give to your bank, to insurance companies, to your trust deed company. When you have an escrow going on for your home, for example, and the escrow company says, "Hey, we need to know how do you want the title of the title of the home." Well, at that time, if you have misplaced your letter, a letter of instructions, how it should be titled, call us, we'll help you. And also many times people have a trust. Turns out they have a trust, everything was transferred into the trust, but later on they acquire some properties, they did not put those into the trust. Guess again, they have a problem. They will end up in the probate court. And also if you refinance real estate, the bank will ask you to take the property out from the trust. And most times they may put it back into the trust. Sometimes they may not. So you want to be proactive that the property is put back into the trust. If it is not, then your property can end up in probate. Now, most trusts have something called pour over will, meaning certain items such as sofa, car at home, or many other things at home, you're not going to be sitting there retitling those in the name of the trust. However, there's a limit as to what can be specified that they should become part of trust upon your death, and that's done through a something called pour over will. So now, a lot of times people think, all my assets that I have not put in the trust, now later on, if I acquire them or if I forgot to title them in the name of the trust, they'll go through automatically into your trust through pour over will. Not so. Only certain items can be put into the trust through pour over will, but not all. So that's another reason why many of the trusts end up in probate courts. All right. So as I mentioned, such are the reasons why many trusts end up in courts. So you want to get the trust done right. And our trust is always reviewed by an attorney. Now, another item that perhaps you may want to know is what happens when I get disabled with my assets. A good trust will plan for that too. A lot of times people say, I'm healthy, don't have to worry about it. Nothing's going to happen to me. Actually, a lot of times we don't even plan for the event of disability. Things happen. If you look around to your uncle, aunts, perhaps in your own family, mom, dad, perhaps they were not as healthy, or they are not as healthy in old age as they were in younger years. So the likelihood that something can happen to you, well, know this, about two-thirds of the people who make it to age 70, they will at one time or the other time will require long-term care, two-thirds. So if you are the one-third, the fortunate ones, well, good for you, but you want to plan if something should happen to you if you're on the two-thirds side. So our trust will actually have proper terms specified in the trust so that in case you're disabled, what happens, how are your assets managed, and also, will your spouse and family be able to help you when you're in the hospital? And let's suppose you're taken to the hospital. Turns out, your wife just got a call, your husband just got a call that you're in the hospital. Perhaps you had an accident and been taken to the hospital, and your spouse runs to the hospital. Turns out now the hospital does not want to share health information because you are not authorized by the spouse to get information on your health. So HIPAA form is required, and without HIPAA form, hospital will not share information. So we actually include HIPAA form and other necessary forms in the trust. And we also want to make sure that you have other important healthcare documents as part of the trust. Okay. Now, let's suppose you do have a HIPAA authorization form and healthcare documents in your trust. That's how most good attorneys have their trust prepared for their clients. They have HIPAA form and healthcare documents and everything else. All right. So now let's go back to the situation where I mentioned that if something happened to your spouse and you had rushed to the hospital because you got a call that your husband or your wife had an accident, and so they've been rushed to the hospital. You just get in the car and go full speed, darting through the traffic, and turns out the hospital says, "All right, do you have the HIPAA form? Do you have these other necessary documents so that we can share information of your spouse with you?" Or perhaps take directives take instructions from you about the health care of your spouse. You said, I have those forms, but they're at home in my trust. Well, the hospital says they are of no use to us unless you want to go back home and bring them. So what happens is you are forced to sign the forms that hospital will present to you. So I got to ask you, when a hospital is giving the forms for you to sign, And also they take the hospital, take the forms to your spouse in the hospital room, and and the spouse will sign those forms, and then you also have to sign. Guess what? Those forms are designed to protect the hospital, not you. So that's why you want to have your own documents with you. So since nobody carries the HIPAA form and everything else in their purse, so what we do is actually, with our trust, we give our clients an emergency access for our clients, emergency access of medical information, so that if you are at the hospital desk, front desk, and they want to know more information about your HIPAA forms and everything else, all you have to present this ID card. The it's not you. It works as an ID card too, but really it's an emergency card. Present this to the front desk. They call a certain number written on this card, and they can get all the information sent to them from this cloud bank that will have all the information about your HIPAA, trust, and everything. Now, also, we want to make sure that all these necessary forms are not just fill in the blank type of forms. They are done correctly, and you want to make sure that they will protect you, that fulfill the need of emergencies when situations should arise. So all those forms, when they're on the cloud, are accessible through this card, emergency medical card. Now, let's talk more things about when you're disabled. Well, now we're going to go not the situation of accidents or other injuries that might happen or major sicknesses that happen and while you're younger, but how about when you're older and cannot take care of yourself? So in those situations, who is going to pay for your long-term care? Whether they're going to be spent from your assets and deplete your assets in your old age, and long-term care is very expensive. So question is, will the long-term care be provided by your spouse, your children, or somebody has to be hired? Or maybe somebody's hired, but your spouse and children assist, sometimes fill in with the outside care. So if you do not have proper planning, the cost will have to be paid by you and your spouse. And many times I've seen children have to pitch in. So that's another issue that you have to deal with in disability planning. We cover all those things in your trust. And what other options do you have to pay for this care? Well, one of the major benefit of having an insurance in our society is that you can also get long-term care insurance. So long-term care insurance will help pay for the long-term care costs. Now, the long-term care insurance, I agree with you, it's not inexpensive, it's very, very expensive, but it is one of the options that should be considered. And if somebody does not have much of an assets, or if the law says you have assets, and so you got to pay on your own. Well, before the Medi-Cal, the state of California kicks in to take care of your health, you have to deplete all your assets. Only then Medi-Cal will pay for your long-term care. Now, there are ways to protect your assets, and those are separate issues. We can cover that at a different webinar, but just want to let you know that these are the options that exist when you're disabled, and we try to cover as much as we can in our trust for you. So to qualify for Medi-Cal, question is, do you have to spend down all your assets? Give away or lose the use or control of assets? Well, many times people say, I'm heading to the long-term care facility in a couple of months, 6 months, 8 months, a year or so, because my health is failing. So I'll pass on assets to my children now. Well, you cannot do that. Actually, if you pass on any assets to your children, anything you passed on in the last 5 years. By the way, it says 2.5 to 5 years. State of California is 5 years. If you have passed on any assets to your children in anticipation of going to long-term care facility, all those assets will be brought back. So the only time that state of California will pay is if you are destitute, they'll let you keep your home while you're alive. But upon your death, if they have spent money on you, the government says, hey, before house goes to children, we want to recover our expenses from the sale of the house. Now, next mistake, not protecting your beneficiaries from. Okay, so you were smart enough to create it. You said, okay, I am going to leave all my assets after let's assume this is happening after both of you have gone, you and your spouse have gone. And your spouse, you said, okay, I'm going to have 1/3. You have 3 children. You want 1/3 of your estate to go to each of 3 children. Question is, are they going to be able to manage the assets properly? Will there be situations where they may end up losing all those assets? So the question is, not protecting your beneficiaries from themselves, another big mistake. Can they be trusted to handle a big pile of cash? Got to ask you, when you were, say, 20, 30, or 40 years old, and if somebody had put $3 or $4 or $5 million in your hands, would you know what to do with that money? Chances are you're going to be running around looking for advisors to help you manage that money. Or perhaps if you're so bold, you may say, I think I'm going to take that money and invest it in some business and make it grow. Some of my friends have made such great investments and they're making big money. I'm going to do the same thing. So your children get all this money and they got big dreams on how they're going to invest, or they're hiring advisors. Either way, things can get messed up. And advisors, if they are good advisors, great. If not, they can be the children can be misled and they can end up losing money. So there are many other situations we're going to show you how the money can be lost. So question is, can your children be trusted to handle a big pile of money? And the answer is no. Best thing is trust your trust instead. The best way to find out if your children can handle the large amounts of money, that's if you're wealthy today. The people right now who are on the webinar right now, I'm sure we have them from all ranges of assets. Some perhaps have average amount of assets, and some have been very fortunate. They might have accumulated 10, 20, 30, $50 million. So here's what I tell my clients. Look, if you think your kids are very smart, do this. Give your children $2 million today and sit back and watch and never ask. Tell them that you're never going to ask them what they did with the money. And indeed, don't ask them. Just watch. The way they'll manage your money after you're gone from this world is the way they'll manage these $2 million. So that's one indicator of how they'll handle the money. But most of us do not want to go through that experiment. A lot of times my clients will tell me, but Paul, I don't need to worry about my beneficiaries. They're all grade A beneficiaries, just the best of the best. They love each other and they're smart. They handle the money. My children are attorneys and doctors. Well, let's see things happen in people's lives, everybody's lives, and we'll now show you the situations that can arise that can mess up the inheritance. What about your kids may be very smart. So what about the damage that may come from third parties? So children inherited significant amount of money, but let's say the dangers lurking around from third parties. How about their spouses? Now, keep in mind, people will say, yeah, then the inherited money is a really separate property. So this spouse has no control, no right on that money. That's so in the law. But here's what happens in real life. Your child, your son or daughter will inherit the assets, and very soon thereafter, they will tell their spouse, honey, whatever is mine is ours. The moment they say that, it indeed is community property. At the same time, let's suppose your child tells his or her spouse, that's my separate property. I'm going to keep it as separate. Guess what? From then on, there's going to be friction in the home, and mine is yours concept sets it in between the husband and wife. And from there on, year 2 or 3, marriage falls apart. I have seen that happen. I've seen that happen in so many families. And you do not want to put your children through that. You do not want to destroy their marriages. So there are ways to protect the assets of your children after they inherit, and we actually do that through a separate trust which can be set up for your children. But at least for today, I want to make you aware that these dangers lurk, and we can actually build clauses that in our advanced living trust. We can actually build clauses which will actually protect assets from your children, your assets of your children from third parties, from their spouses. Excuse me, because somebody's trying to distract me on the side here, trying to get my attention. So, all right, let me finish the webinar first, okay? Then I'll answer your questions. Okay, thanks. All right, and so things can happen. What else can happen? The bad luck, creditors, bankruptcy. And suppose you're one of your children has built a very successful business and something goes wrong. Now guess what? Creditors are after your child to recover the losses, and they'll go after everything that's in their name. And many times people get hit with lawsuits that they're valid or bogus, especially if you're wealthy, you're always getting hit with bogus, sometimes bogus lawsuits. And valid, yeah, there's nothing we can do to protect you from a valid lawsuit. That's your attorneys, the attorneys you hire at that time. That will be their job. However, if the assets that your children inherit are protected in a separate trust, remember, they will not own those assets. They'll be in a separate trust for your children. So if they don't own it, they cannot lose those assets to any lawsuits. So whether they're valid or bogus, they still cannot. But in your own life, of course, then the bogus lawsuits, valid lawsuits, you got to deal with them. But at least for your children, you can protect them from all lawsuits. Now, another thing that you need to worry about is the government has their eyes on the assets of your children. So if they owe money to the government, they can go after the assets that they inherited from you. But if those assets are inside their children's own trust, then they're protected. And let's suppose none of these things happen. None of these things happen. Your children actually have a very good luck. They grow the money, and let's suppose they inherited $2 million or $3 million by the time they go. Now, guess what? They have about $5 million have grown to $45 million. Now, when their children inherit that money, they got to pay inheritance taxes on that. So not only your children pay inheritance taxes, then their children will be paying inheritance tax on the same estate. So with proper planning, that can be minimized. So outright distributions should be no. As I mentioned, it should be passed on through a separate trust for children. Again, that is I would say, add on to a living trust. The reason we want to actually give you this information today, most attorneys will not talk to you, most financial advisors will not talk to you, but we want to at least plant a seed in your mind that living trust for you is good, you should have it, but at the same time, you should be aware of the fact that you want to actually create a separate trust sometime in the future, now or sometime in the future, to protect the assets that your children will inherit from you. We call that legacy trust. And that's not something urgent that you need to do at the time you create your own living trust, but it's something to discuss with your attorney. With a legacy trust, your beneficiaries can manage and control it and have access to the assets in there. They can use those assets, but still they're protected from creditors. So here's the situations. Let's suppose you have 3 kids. Bob, or not you, let's just think of us as a client who has 3 kids, Bob, Jane, and Jim. Now, Bob is a very successful doctor, but guess what? Being a doctor, he's in a risky business. And he may also have a high maintenance spouse. He does very well in terms of his own income, his building his own assets, and the assets he received from you as inheritance. Well, he manages those very well. Everything grows to a big amount. So what can happen? Now his children will have to pay inheritance taxes on what you left behind. So first, Bob may or may not have paid taxes on the inheritance from you, but your grandchildren might have to pay inheritance taxes. So the dangers remain from the high maintenance spouse, risky business, second estate tax. With proper planning for children, they can be protected from all that. And then let's look at Jane. She may not have experienced how to manage the assets, or she could be having a problem marriage. So then you want to protect the inheritance they received from you from all those issues. And how about Jim? Let's suppose Jim has a bankruptcy or creditor issues, and government so he might have qualified for government benefits. He will not qualify for those government benefits if he receives inheritance outright from you. So with the legacy trust, all 3 children are better protected. So when we do the planning, when clients come to our office after, or even during the time we were doing the living trust, we actually educate them on the legacy trust so that at least that idea is in the back of their mind, and to do a proper trust planning, complete trust planning, that should become an add-on to the standard living trust. Now, another thing people think is, hey, since you have a trust, everything can be put into the trust. Thing is, IRAs, 401ks, pension plan assets cannot be put into the trust. You should not put into trust. That would be a big mistake. And today, those assets are turning out to be much larger than all other assets of the clients. So you want to make sure that there are languages in the trust that will help protect your, at least we will issue letters to you along with the trust to guide you on how to protect and grow your retirement assets. And another issue is the estate taxes. Many times people say, "Oh, everything's taken care of. I have a trust. I get everything's taken care of." Actually, I've seen that happen again and again, even with clients who have huge estates, 20, 30, 40, 50 million dollar estates. Once they have living trust, they think all the issues are taken care of. The standard answer they give is, "Oh, everything's taken care of," but they don't know that It is not. If their estate is large enough that they'll have to pay, kids will have to pay inheritance taxes, they don't know that their living trust does not protect their assets from the attacks of IRS for inheritance taxes. Now, a living trust will provide limited protection to this in the sense that it can help preserve the lifetime exemption that every parent has, everybody has, that you can give up to so much from your estate to your children and not have to pay inheritance taxes. So with a trust, husband and wife both of those, by the way, this is called lifetime exclusion. From if with the trust, we can combine the lifetime exclusion of both parents and preserve it. But anything over and above the combined amount will still be taxed for inheritance tax purposes. And inheritance tax is due within 9 months. And if the children do not have the money to pay inheritance taxes, they'll be forced to sell properties to raise cash to pay taxes. Currently, by the way, the lifetime exemption per person is $11.7 million, but under Mr. Biden's proposal, it's coming down to $3.5 million if the proposal is passed. And with Mr. Bernie Sanders and Mr. Biden and Congress right now, worried about the deficit that has built up in the country, they are going to be looking at all possible ways to raise more taxes and reducing the lifetime exemption from $11.7 million to $3.5 million. Well, that remains a very good possibility. Some of you perhaps on the webinar right now may be saying, but my estate that's nowhere close to that. My estate is only worth $5 million. Well, that may be today, but if you were to actually project that into the future, assuming that your estate doubles every 10 years, so 5 million is going to grow to 10 million in 10 years, and in 10 more years, it's going to go to $20 million. So will that be subject to inheritance taxes? Of course, under current laws at $3.5 million, not the laws that are coming very shortly, under that rule, yes, your children will have to pay inheritance taxes. What the laws might be in the future, we do not know. But the country has been running on huge deficits, taxes going down in the future years. That could happen, but at least we advise our clients not to prepare for that. Plan on IRS and Congress raising taxes by every possible means. So, are there ways to minimize your inheritance taxes with proper planning? Yes. First step, of course, would be living trust to preserve the lifetime exclusion for both of you in the family. And then also there are other means and tools we can share with you on how to prepare your children to pay inheritance taxes and not have the whole big chunk taken out of what they inherit. So in a good trust, we have planned for AB, living trusts, so that both the assets of both the spouses are preserved. Not the assets, and the lifetime exclusion of both assets is protected. And also, I think you already know that the same-sex couples now are treated as married. So if you are single with an estate of over $4 million or married at over $8 million, you need to consider planning beyond the living trust. That's where I mentioned to you about the inheritance tax issue. So that is a separate issue. We can cover that on a one-to-one basis. When you call us, we'll be happy to guide you on depending on your personal situation. And we've had long-term experience with trust planning for large estates. I have worked with some of the best-known attorneys in the country. These are the people who have actually designed the trust for some of the wealthiest people in the country. So those are the people I consult to help my clients. We have attorneys for average estate. We have attorneys for very, very large estates. A lot of times people may want to look at many different issues to many different ways to minimize the inheritance taxes. We explore all those possibilities on a one-to-one basis when your estate is large. Another thing is to many times people put their friend, brother, or their son as the trustee of your trust. You need to know that the management of trust is not an easy job. So you need to actually have proper selection of the right person who is experienced, secure, who will know how to handle the trust affairs, and will be happy to actually give you a whole book on for the trustee that you can keep as part of your trust. It is we call it trustee handbook. And if the trustee does not know how to manage the trust, then the whole process will have to go through the court system. So court will supervise, and you do not want that to happen. The trustee does have personal liability, and so you again have a language in the trust that is to a certain degree your child, if your son is the successor trustee, that at least up to a degree he does not have to buy bond to protect the assets, because if he's responsible, if it can be shown he's responsible, then it can avoid the need of a bond. So in your trust, you want to make sure that your trust is updated on a regular basis based on your wishes and changes in relationships. Many times people, like I mentioned earlier, they may put their brother or friend as trustee. That might have been 5 or 10 years ago, but say if the situation has changed, the relationship with your friend may not be the same, or your friend might have become too old over the years, or his health may have changed. So you want to put a different successor trustee. Successor trustee being the contingent trustee after your spouse. Your spouse generally is kept as the first trustee on the trust after you go. So as the laws change, you want to make sure that your trust stays compliant with the tax and trust laws too. So doing all of that on your own is not an easy job. It's complicated, and what we do is we advise our clients go with a firm that has experience, and that's why you need Signature America to do the proper job for you. Our firm, we actually answer phone calls for free. We, unlike attorneys, many attorneys, what we'll do is I'm the financial advisor. I'm the one who actually is supervisor of the attorneys and accountants in my office. So when you have a question, you ask me. Most times I might be able to answer. If not, then I'll ask one of my attorneys to get the answer for you. And for small questions here and there, we do not charge you any fees. But with a regular attorney, anytime you make a call, guess what happens? You're billed for a minimum of 10 to 15 minutes. And I've seen these attorneys actually for simple questions and ask for $200 or $300 because their fees are $800 to $900 an hour. We keep you informed with periodic newsletters and special notices on seminars. And we also have special family discount. And we offer a free checkup meeting every 3 years. And then we also help your survivors. But what's the main reason people have not done their estate planning? The number one excuse is, oh, I've been thinking about it. I've been thinking about it. I know I'll get to it. I'll get to it. I'll do it next week. I'll go do it next month. So that's called procrastination. So chances are you've been thinking about trust planning for the longest time. Now may be the time to set your foot down, say, I'm going to get it done. I'm going to get it done. And right now is your opportunity to do it. And we are here for you. And we have special discount for people who take the necessary steps within the next 24 hours. So where do you go from here? Start your living trust today. And our standard living trust price is $999, but we are giving $100 discount to that office webinar. And that discount is only to the first 7 people who sign up. So I would suggest that as soon as the webinar is over, you should go to our website. I'm going to give you the address. You should sign up before you lose the potential discount of $100. Be one of the first 7 people, and we'll hold your hand and set up the best trust, best living trust that you should have as part of your portfolio. And incidentally, this price of $999 does not cover that. It does not create a trust for the following situations. If you have a disabled child, that will require more advanced trust. If you're disinheriting a child, that too will require special trust. And if you have some child outside of your marriage and you have problem situation, then too, we will not be able to create trust for you for this price. So remember, you get $100 discount if you're among the first 7 people. And the web address you need to go to is trust-planning.org. Trust-planning.org. Go there as soon as the webinar is done in a minute or so, and sign up for your trust. All it requires is $99 deposit as a guarantee to lock in the price. Remember, just like no 2 cars are alike, some are good, some are not good. Some are safe, some are not safe. Same thing, you want to have peace of mind, having a good trust, and that's what you get from us. So what's included in the trust? Family trust, last will and testament, power of attorney, medical power of attorney, advance directive, HIPAA authorization, transfer of home deed to trust. That's included as part of your trust. We'll transfer the deed of your home to your trust, and that's worth $250. If you were to ask some local escrow company or attorney, they'll charge you between $250 to $300. So that's included as part of your trust for free. And we'll also issue you documents to help you retitle your accounts with the bank and insurance companies. And we also will give you an asset map of your assets that's worth $199. And we'll also give you a wisdom letter template, a wisdom letter that actually is a letter from you, from your heart to your children, which they will open the letter after you're gone. And in that letter, you actually specify your dreams, your aspirations for them, and the values that you would like them to live by. Children actually respect that letter, and try to absorb the values you set forth in that letter, that they try to make it part of their life. They value your last words. So any questions, please call us or write to us. And here's our office number. But for those people who are attending the webinar, here's my personal contact information. Please write down now, of course, my name is Paul Kalra, and my cell number is 949-910-8019. Please feel welcome to call me. And my personal email address is paul@happypaul.com. Paul@happypaul.com. Thank you for attending the webinar. Sorry for keeping you on the webinar for 4 minutes extra beyond 1 hour. You have a great day. Bye-bye now.